This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Professor Gregory Ogden to the show. Now, Professor Ogden has over 40 years teaching civil procedure, administrative law, remedies, and legal ethics at Pepperdine University. He's a published author, consultant, and public speaker. Professor Ogden is a sought-after expert witness and holds a JD from UC Davis. Mr. Ogden, thank you so much for joining me here today at the Roundtable.
You're welcome. Yes, it's fun to be here.
Let's jump into it. You've had a long career in academia, but how did you first become involved in expert witnessing?
My first case involving expert witness was in the early 1990s. It was at the same time as the O.J. Simpson criminal trial, where Mr. Simpson was charged with murdering Nicole Brown Simpson and Ron Goldman. And this was also in the era when cable TV certainly became very prominent. And there a lot of my colleagues who had any expertise in criminal law were cable commentators on the Simpson trial, along with professors and a lot of other places. Well, I didn't become one of those commentators, but I got involved in a case that was brought by a former student at Pepperdine. I didn't have this person when I was a professor, but he was representing a client who was suing a law firm, and there were issues dealing with legal ethics, in particular with the duties that lawyers owe to former clients under the conflict of interest rules that govern lawyers in the state of California. So that was my first for a case where I was retained as an expert witness. My deposition was taken. I gave trial testimony, and as we were leaving the courtroom, the day after I gave my trial testimony, we heard cheering from behind the closed doors of the LA County Courthouse, and we discovered pretty quickly that the verdict in the O.J. Simpson case had come down. So very quickly we got out of downtown, but that was a very memorable case for me because I had never done expert witness work before. I had taught the class in legal ethics, which provided the basis for my understanding of conflict of interest law. Really since the beginning of my career at Pepperdine in 1979. But it was an interesting experience. The law firms on both sides were quite good. The opposing experts were also quite good. And I had a certain amount of, let's say, nerves, because this was the first time I had done any of this kind of work. And I had been a lawyer for 3 years before I went into law teaching, but certainly nothing, most of my work was in administrative law.
Well, so you have, kind of the trifecta. You were an attorney, you're in academia, and an expert witness. So you've kind of seen this from all of the sides. Let's talk about, expert witnessing in general. As an expert witness, when you're in that role, or even as an attorney, what is meaningful? What's important about being an expert witness?
What I like about expert witness work is that you're presented with a problem and you're presenting with conflicting views on the problem, and you can use your brain power to help solve that problem in a way that is responsive to the needs of the lawyer you're working for and the client or clients that they're representing. So it's fun, it's dynamic, there's always some unknowns. But I always enjoyed doing trial work as a young lawyer. I didn't do any complicated cases, but I liked the trial work for the same reason. And so being an expert is fun from that standpoint. It's, of course, also, it can be challenging because you're in an adversarial environment. And there's always experts on the other side who disagree with your opinions.
You've been doing this for a while, so I'd like to talk about how the role has changed a little bit over the intervening decades from when you first got started. How has the role and the expectations and the logistics, how has the job changed fundamentally? I'm sure that one of the big things is the advent of the internet, or at least it being introduced to the masses.
I think that's absolutely the case. The internet is ubiquitous, which means there's a lot more information out there about experts and about their roles in previous cases. And so I think that can present challenges because the pace of lawyering, the pace of life in more general, the pace of information and the amount of information that is available makes it much more challenging to be an expert. And of course, opposing counsel always want to find out what you've said in other cases. And that's much easier now with the internet because you've got past sorts of information that are much more easily preserved now.
Are there things that you can do or strategies you can employ to help mitigate some of that, or is it just a fact of life and you just have to deal with it?
Unfortunately, the internet is here to stay, and of course, I haven't dealt with the impact of AI on expert witness work. That's sort of an up and coming kind of issue.
Right.
But I think you're just stuck with being in this environment where there's tons of information out there. Not all of it reliable, of course. But back in the 90s, when I first started doing this, the range of information you had to address and the actual how you actually work with information was much different because everything was in paper, and it was really hard to research prior cases in which your expertise might be questioned, if you will. Now it's very easy because any search engine you can use will pick up all sorts of things.
Has that affected the vetting process itself to some extent?
I think so, because I think if you are a prominent expert, opposing counsel is going to want to know if you've expressed opinions in prior cases that are consistent or inconsistent with the opinion in the current case.
Let's talk about the future where this is all going. You mentioned AI, which is really interesting. Do you have any ideas on how AI may impact the industry, the profession of expert witnesses?
Well, I think we have to worry about a lot more faked information. And of course, AI is something that lots of people are talking about. Lots of people are worried about it with our upcoming election. I think it's possible that AI could be used to generate, fake news and false information that could impact how experts reach their opinions. But it's still one of those things that's in the future. We don't know exactly where AI is going. But it's something that should be troublesome because if we can't differentiate between truthful information and false information, it's going to be much harder to offer expert opinions that are helpful to triers of fact in litigation.
As a professor, one of the things that you're a professor of is legal ethics. How does AI implicate legal ethics in general? What are the sorts of what are the sorts of things that attorneys have to look for and watch out for as AI becomes ubiquitous?
Well, of course, attorneys representing clients are advocates. They're advocates who are supposed to be zealous within the bounds of the law, but they're also officers of the court. So they're not supposed to, suborn perjury or condone perjury, and they're not supposed to put forth false information. So that duty of being an officer of the court versus being a zealous advocate for their client can clash. And the ethics rules are pretty clear that you're not supposed to offer false evidence, or you're not supposed to encourage a witness to testify falsely. And of course, as many lawyers know, of course, lots of people don't tell the truth in litigation, but the lawyer can't be directly involved in that or know that that's the case. And so I think AI is going to make that much, much harder to vet false evidence and to vet false testimony.
Let's move on to our main topic, which is going to be report writing and expert reports in general. This is something that most expert witnesses are going to have to deal with at some point, whether it's an initial report, a rebuttal report, or some back and forth or in between. So tell me about expert reports in general. What are some of the main considerations when an expert starts writing their report?
That's an excellent question. And I should tell you that in California state court expert witness practice, there are no expert reports. And the lawyers don't want their experts putting anything down in writing
No
because
kidding.
that can be used to, for cross-examination or for tough questions in discovery or deposition practice. So, so I think that is an unusual practice. Certainly in federal court, there's expert witness reports, and in most states that have a version of the federal rules, you have state expert witness reports as well. But I've written expert witness reports, but only in maybe 3 or 4 of the cases where I was an expert that either started in federal court or that were removed to federal court. So if you're a California state court expert, you don't write an expert witness report, which means when you're preparing for a deposition and for trial testimony, you got to rely pretty heavily on your memory. But
Wow. So what do experts do in lieu of reports? How do they get across that they're an expert without being able to, in a very, let's say it's a very complex case with a lot of technical details. How do you navigate that?
it's extremely difficult, but I was able to rely on the fact that I have, or had anyway, an almost photographic memory. So I was able to rehearse in my mind all the things I needed to talk about as I got ready for depositions and then in depositions itself. So, so in that environment, it's you really have to have a good memory and a good sense of organization. So, given my preferences, though, I would much prefer, in all cases, to write an expert witness report. And the reason for that is that you typically go through drafts in your expert report as your understanding of the case evolves, and you get feedback from the lawyer that you're working with. And once everything is all complete and tied up like a package with a bow, you have your report. And then that report provides a basis for a deposition and for expert testimony. And everything's in black and white, it's clear. So I much prefer that because you don't have to rely on your memory as much. But as I said, only in a few of my cases was an expert witness report required. As I said, those were either federal court or one case that was supposed to be tried in state court. The lawyer removed it to the bankruptcy court. So expert reports, they're critically important when you're in a court system that requires them, which most do. And of course, your expert report evolves as you consider more information related to the case. So based upon a lot of information, in most cases, I was retained fairly late in the discovery process because the experts wanted me to be able to review all the depositions of the fact witnesses. And when you're in that setting or that scenario, then you have a lot more detailed information that you can rely upon in writing your expert witness report. So, or in this California practice is really anomalous. It evolves over time. So as I was saying, the expert reports, your thinking on this evolves as you review more material and as your brain's operating. And one of the things that's sometimes challenging in this is that when I'm doing some expert work, I can almost never shut off my brain. So I have to figure out, okay, I can't bill for 24 hours a day. So I have to kind of figure out, okay, what's reasonable in terms of thinking time and what's reasonable in terms of, oh, I didn't think about this particular point. So having an expert witness report forces you to put those things kind of into a very specific context.
Are there formatting considerations? Is it critical the way that you organize your report, or do you kind of just organize it the way that you think in general?
I typically try to organize it based upon the questions that my expert opinion is being offered about. But there's sort of a standard format in that I first talk about my relevant expertise. I talk about the retention agreement that I have with the lawyer that I'm working with, and then I will go into the questions that they've asked my expert opinion on. And so
Okay.
that last part is the lengthiest portion of the report, but that's the part that I end up having to think about and saying, okay, have I got everything? Have I put everything down that reflects my understanding of this issue?
Does it help to have a glossary or appendices if it's a complicated report or a lengthy report?
Probably in certain fields it would. And when I did that conflict of interest case, that's complicated enough. This was a jury trial of lay jurors. So in that case, I definitely, although that was a state court case, so I didn't have a report, but the lawyer who I work with had me go through and define some terms, and those then went into jury instructions that the lay jury could understand. So there's a challenge here. You have to be accurate as an expert, but you also have to be able to communicate things that are understandable in a jury trial. Now, if you have a drug strike case, it's not as important, but in any case, that's always a question or an issue.
In a jury trial where you have a technical area of expertise and you are dealing with a presumably lay jury, or at least partially lay jury, how do you go about writing a report in such a way that it communicates all of the important technical details while remaining understandable to laypersons, including the judge?
Well, fortunately for me, most judges in the American legal system are also lawyers, and they had to have been lawyers for quite a while before they went on the bench. So I didn't have too much difficulty communicating concepts to the judges. But with the jury, this is a real challenge because you want to be exacting, and you want to utilize your expertise in an honest way. On the other hand, it's like jury instructions. They've got to be accurate, and they've also got to be understandable. The same thing is true with expert opinions and expert reports. They've got to be accurate, but they have to be understandable. There's a tension there between those two competing goals. Now, I don't think that the tension for legal experts is as great as it is for experts in other scientific disciplines, where very few people have an understanding of that particular discipline. But it's a challenge. I agree. My advantage maybe is because I'm a law professor, and I'm retired now, but I was a law professor for 44 years. So I was used to presenting concepts to my students in an understandable fashion. And while students are future lawyers, they're still learning. So they're, of course, a highly educated subpart of the population, more so than jurors. But the magic of the jury system is that you get a group of people together. No one person is going to pick up everything, but when you've got a larger group of people, you'll find an awful lot of understanding of the nuances of witness testimony.
Is general writing technique translatable to something like an expert report? In other words, if you're a talented writer, if one of your students is turns in assignments that are well written, are they likely to also be good at writing expert reports, or is that an entirely different skill?
It's interesting because a colleague of mine has recently started writing fiction. And he said fiction's a lot harder to write than nonfiction because you have to create the whole universe in which your work takes place. Whereas with nonfiction, you have a real world set of facts that you can work with. So I would say students that are good writers will make very good appellate lawyers. They won't necessarily be good trial lawyers because the skills for good trial lawyering are quite different. But if you are a good writer, you can learn to be a good advocate. And of course, experts in our American legal system, you're experts in an adversary system. So you're not an objective expert looking at both sides of a question. You're an expert that is taking a particular position in a case that's consistent with the objectives of the client that the lawyer working with is representing. So I always, before I agree to take on a case, I need to know enough about the case to know, is my opinion about this consistent with the position being advocated by the lawyer? Because if it's not, then I can't be their expert.
So is that something that you typically determine in the initial phase and during the first phone calls?
It is. Now, if it's if so, about 50 to 55% of the cases I worked as an expert, I got those without the use of an expert witness service, mostly from former students or colleagues who had expertise like mine, but didn't do that kind of work. So in that setting, I would talk to the lawyer. I would get through enough of the fact questions to say, okay, my opinion is going to be helpful to you. Or if I found that it wouldn't, I would say, I can't be your expert, and here's the reasons why. With the expert witness services, a lot of that information is presented initially by the expert witness service, and then you respond to a series of questions. And then based upon that, your response to those questions, the expert witness service talks with the lawyer. And then if there's a meeting of the minds, then you go forward and talk to the lawyer yourself. So, so there are a number of expert witness services. They all operate similarly in the sense that they give you a set of facts and basically wants you to offer your opinion on that, as well as your expertise in that particular area of trial work. So with those, then I fill out the answers and I wait to hear back from the attorney or from the service.
experts, tend to have fairly broad expertise in their field. How do you remain concise in a report? Because, it can be easy to want to say everything that you know on a specific issue, but how do you keep it within the four corners of the questions that are at hand and not just spouting everything that you've ever learned about your field?
I would say that takes experience. And I think one of the advantages of being an academic expert is that my day-to-day peg check is not based upon my expert witness work. It also, as I said, I've had to learn in teaching students over the years how to break things down into the simplest concepts possible so they can understand them. And I think those same techniques go into being an expert, writing an expert witness report, or giving expert witness deposition or trial testimony. So it's not necessarily easy, and it takes some time and thinking, but it is possible to do. And of course, if you're a young expert, you're just starting out, this is one of the things that you have to learn how to do, which academic experts might have a bit of an advantage. On the other hand, real world experts, they will say, well, I'm in the real world, you're just in the ivory tower. So your opinions, really aren't that valuable. I would, of course, disagree with that, but I would say it takes time and experience to learn how to structure your report or structure your opinion in a way that's appropriate, doesn't bring in everything but the kitchen sink, and meets the needs of the lawyer and their client that you're working with.
Beyond that, are there any other common pitfalls vis-a-vis report writing that newer experts are likely to stumble upon?
Yeah, that's a great question. I would think that as you're writing your report, sometimes you get to a question that your thinking on changes over time. And so you want to be aware of your thinking taking you in a direction that the lawyer and the client don't want you to go. So in some cases, experts will just say, well, my opinion is limited to A and not to B, C, and D. And that could be a way around that particular problem. And that can avoid your deposition testimony or trial testimony being problematical for the lawyer and your client. And indeed, depending upon the opposing counsel, sometimes your deposition testimony can provide the basis for cross-examination later on in trial. However, my experience is that in most cases that I was involved with, they didn't go to trial. They settled often on the eve of trial, and that's because lots of judges today, they want these cases to settle. They don't want to have to try them. And so I was in my early years, my expert experience led to not only depositions, but trial testimony much more frequently than in the last 10 years. And so, I mean, it's your expert opinion or your report or your expert opinions. So without a report, oftentimes help facilitate settlement because it gives both lawyers a sense of, the strengths and weaknesses of their case.
And that brings us back to earlier, we were discussing the present and future of expert witnesses, and obviously a lot more cases are moving to settlement these days. It's interesting you mentioned that judges are pushing for settlement. Do you find that it is typically the judge is playing a big factor in why more matters are moving to settlement?
I would say the judge has an important role, and most judges now, technically, in some systems, the judge who tries the case is not supposed to try to settle it, but that's not the rule in all cases. In the California system, judges who are getting ready to try the case often can try to settle on the eve of trial. So the judges try to do that, but also if there are insurance companies involved in litigation, they often want to settle. And the lawyers that work with him often want to settle the cases because they're worried about verdicts that are well above the assessed cost of litigation to the insurance companies. So I worked on a case recently where I didn't think it was going to settle, but it settled on the eve of trial. And that was after expert depositions. And I think both lawyers looked into the mirror, so to speak, and said, okay, there's problems with each part of our case on both the plaintiff and defense side. So let's see if we can come up with a number that everybody can live with.
You've mentioned a few times about the differences between California in particular and federal, not to mention other states. But how do you recommend that experts contend with that? Is there something that experts need to do to prepare themselves to work in different venues, or do they just rely on the attorney and go from there? Is there any preparatory work or any strategies that they can employ to make sure that they're ready to work in a venue that they may not always be in?
Now, that's a great question. So one issue that arises is the sort of scope of your expertise. So my expertise in most of the cases where I was an expert witness was in legal ethics or in uh, the duty of care and legal malpractice cases. And so that was very much tied to my experience as a California lawyer and California law professor. So if your expertise is jurisdiction specific, which of course it might be as a lawyer, then once you get outside that jurisdiction, nobody's going to accept your expertise as being particularly valid. So that's one question. Another question, of course, is how the court systems operates. And in the federal court system, there's definitely a push to complete discovery within 18 months of filing, which is really, really brisk. And so the magistrates that often are involved in that will push the parties to complete discovery. And then once discovery is complete, you might sit there and wait 3 years before the case comes to trial. So that's another factor as well. And then in one case where my administrative law expertise was used, you had a very unusual system where you had challenges to an IEP for a particular student in a school system. That was first assessed by a hearing officer working for the state. And then the appeal was to the US District Court, which was really crazy. In that case, the district court had de novo review power. So in that case, I had to structure my report in a way that helped the district court to see that the particular hearing officer whose decision we were challenging violated all the norms of administrative law. So there I didn't give testimony, but I did do an expert declaration. And often expert declarations are helpful in mostly in avoiding the grant of a summary judgment motion by opposing counsel.
For our listeners who aren't familiar with declarations, can you describe what that is?
Basically, a declaration it used to be called an affidavit, but now in most cases you can complete a declaration and you swear under penalty of perjury that's true and correct. And declarations are frequently used by fact witnesses that the lawyer is not able to call. But expert declarations are designed to put forth the expert's opinion in writing. And those, of course, are widely used in California, even though there's no expert reports. And my experience with doing declarations in California was typically to oppose a summary judgment motion. And in one case that I remember where I used that fairly successfully, the lawyer who retained me was the third lawyer on that particular case. And the first two lawyers, I looked at the discovery of it, and the first two lawyers clearly did not understand the claims and issues being asserted by their client. Lawyer number three did. And so I was able to assist that lawyer. I did an expert declaration, and the judge denied summary judgment. And then, of course, we went through full discovery. And then on the eve of trial, that case settled as well. And that was a case where the judge had the lawyers in his courtroom for several days, hammering out a settlement. But he was very, very successful in doing that. So declarations can be used by experts to offer opinions. Like I said, typically it's in support of a summary judgment motion or in opposition to it.
Beyond choice of venue, there's also obviously different types of cases, mass torts, class actions, intellectual property, etc. Are there differences in different case types that expert witnesses need to be aware of and prepare themselves for?
I mean, yes, there are, of course. I never worked on any really complex cases, but there certainly are environmental law experts who've done that. In most of the cases I worked on, the vast majority of them were legal malpractice cases. And so those are tort cases, an area of law that's understandable to most lay jurors and stuff like that. But the other area I did a lot of work in was administrative law cases. And those cases were always in a specific regulatory area of law, such as environmental law or special education law. And so my role was to In some cases, I was a consulting expert, but when I was a testifying expert, my role was to put forth the administrative law principles that applied in this particular regulatory law area. And of course, that's something that's part of my teaching in that particular subject as well. So the type of case can definitely make a difference. And if you're in a more complex case, not only is there a lot more information to process, but there's going to be a lot of experts, some on the same side, some on other sides. And I worked on cases where there were other experts, but none of the lawyers that I worked with wanted me to coordinate with other experts. So I'm not really sure why that was the case. But the experts were typically in other fields, accountants or economists or other things of that sort.
You mentioned the distinction between a consulting witness and a testifying witness. How are what are some of the differences between those two jobs that an expert might do, and can one turn into the other?
Good question. Occasionally, a consulting expert becomes a testifying expert, but in my experience, because most of my consulting work was in administrative law, my assistance to the lawyer was to help them understand the administrative law principles so they can more effectively represent their clients. Sometimes that meant I'd ghostwrite briefs for them. Others meant that I read their briefs and gave a lot of feedback on that. Uh, and so, as a consultant, they wanted my expertise, but I couldn't testify to a fact dispute in that area. And that's the main difference, at least for the type of consulting versus testifying expert that I was. In some other cases, consulting experts become that because the lawyer doesn't like the opinion they offered and says, I don't want you testifying for me. But that was not my experience.
Before we wrap up, do you have any last advice for expert witnesses, and in particular, newer expert witnesses?
Well, number one, I would say being an expert witness is really a lot of fun, even if there's a lot of adversarialness to the process. So it's a lot of fun. And every one of those cases, I learned something new that I was able to take back to my classroom as a professor. So it was great for my students. But the biggest challenge I had as an expert, as I said, is being not able to turn off my brain when I was in the midst of this expert witness process. And so that no matter how many cases I did, that created a degree of tension and a degree of saying, okay, I've got to stop thinking about this, but I can't. So I don't know how lawyers who are advocates all the time do that, but that's something to avoid, to say, okay, I've thought about this enough. I'm just going to shut things off. But it's great fun. If you're a professor who's an expert, as I said, you learn things that you can take back to your students or to your writing. If you're a lawyer who's also an expert, often you'll work with groups of other lawyers. In one case I did, the expert on the other side was an expert that was used by this particular law firm in a number of cases. So they had a good working relationship. But an academic expert, you can say, well, I'm being paid to do this, but this is not my primary source of income. Whereas if you're a lawyer expert, you're always kind of subject to that criticism.
Absolutely fascinating. Thank you so much, Professor Ogden, for joining me here today.
You're very welcome. I enjoyed it very much. I hope things work out well with the audio transcript.
I'm sure they will. And thank you to our listeners for joining me for another discussion at the Roundtable.
And
Cheers.
Roundtable Group is a great group to work for.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.